Hello and welcome to this case law briefing on HMRC versus BlackRock. And what we'll go over is the basic facts of the case, the decisions on the transfer pricing issue in the case. We'll go over the relevance of the legal fact pattern in terms of the outcome and in similar situations. And we'll talk about the key takeaways from the case. So looking at what happened was in 2009, BlackRock acquired a business, namely the North American investment management business of Barclays Global Investors, and the purchase price was around $13 billion. Shortly after that acquisition, the BlackRock group refinanced the target group and put in place the intermediate holding structure that you can see on the right-hand side of this slide. So you can see it was actually a US, UK, US sandwich. In other words, it was essentially a US acquisition by a US entity. But in terms of the restructuring and the refinancing of the BidCo and group immediately afterwards, the structure involved inserting a UK tax residence entity. And as part of that structure, the entity LLC4, which is second from top in this diagram, made a loan of approximately $4 billion to its 100% subsidiary, LLC5. And a key part of the fact pattern was that the legal documentation of the loans, in fact, they were in Eurobond form, did not include any security or any covenants given by the borrower or its subsidiary entities. So as part of this structure, LLC5 claimed loan interest deductions for UK tax purposes, and unsurprisingly, HMRC challenged the deductibility of interest on the loans, and this was on two grounds. The first ground being transfer pricing, and the second being unallowable purpose. So in this short discussion, we'll only look at the transfer pricing considerations here. One other element of the fact pattern that is important to note is that BlackRock, the group, knew that implementing this structure would be regarded as aggressive tax planning, and it knew that doing so would be likely to adversely impact the whole of the group's relationship with HMRC, so not just in relation to this specific structure. Let's look at the two major decisions. So we have the upper tribunal decision in 2022, followed by the Court of Appeal decision in 2024. On the left-hand side, the upper tribunal decision upheld the HMRC challenge on both grounds, so the transfer pricing grounds and the unallowable purpose ground. The tribunal found that the presence or absence of covenants materially changes the economic nature of transactions of this nature. The tribunal refused to impute covenants which did not exist in legal reality, and also the tribunal accepted witness evidence, which was that no third-party lender would have lent without covenants or security or both that would have given control over the underlying revenue streams. In other words, from a transfer pricing perspective, it was a binary decision. So the tribunal found no third-party lender would have lent in such circumstances, and therefore the transaction was not recognized, and therefore from a purely transfer pricing perspective, the interest deduction would have been denied. And you can see the quote in the bottom left here: third-party covenants that were not given as part of or in support of the actual transaction cannot be considered to be part of the hypothetical transaction, as this materially changes the surrounding circumstances and alters the economically relevant characteristics of the transactions in question. So that was the 2022 decision. If we move on and look at the Court of Appeal decision in April 2024, so the Court of Appeal agreed with the conclusion of the upper tribunal on the unallowable purpose challenge, but with different reasoning, and therefore the same overall result was given in the case. In other words, HMRC won. However, the Court of Appeal disagreed with the upper tribunal on the transfer pricing issue, and it's effectively said that the lender's control over the borrower and its subsidiaries meant that the actual transaction was comparable to one with security and with covenants. And you can see the quote on the bottom right-hand side. In the real transaction, the lender had no need of any of the covenants considered by the experts because, quite independently of its ownership of the borrower, it had control of the relevant subsidiaries, and therefore the lender had no, quote, real-world concern that members of the subgroup might take on excessive additional debt or that they might grant unacceptable security to other lenders. That was the correction and clarification, if you like, by the Court of Appeal. So the question is, where does that leave us in terms of the transfer pricing analysis and the proper design of related party financial transactions? So does that mean that security and so on can just be ignored? So the answer is no. This slide to summarize on the relevant fact pattern elements of intra-group financing arrangements from the perspective of the main three scenarios here. So you can have a downstream loan from parent to subsidiary. You can have a sideways loan between sister entities, or you may have an upstream loan, so from a subsidiary to the parent. And it's important to break down the different elements of the legal fact pattern in terms of potential relevance and to be clear on the basis of BlackRock which aspects are less relevant and in which circumstances. So let's go over these factors from the top. Looking at the blue group of factors, so group financing and cross guarantees, in other words, third-party debt and security packages and what cross guarantees are in place. Clearly, that's going to be a material part of the legal fact pattern, whatever the relationship is between parent to subsidiary. Existing intercompany agreements, including existing loan agreements, those are always going to be relevant because where a new structure or a variant to a structure is to be put in place, then there is always the consideration, well, from the perspective of each participating entity, why would it change from the current scenario to the proposed future scenario? So this was not so much in play in relation to the BlackRock scenario, but it has been central to various other cases, such as the Australian case of Singtel. And then we have the regulatory framework. So that includes not just whether individual entities are regulated, for example, for financial services or pharmaceuticals sector purposes, because that may have an impact on regulatory capital and so on, but also legal restrictions that impact debt, such as specific local caps on the amount of interest which may be payable. So those issues, legal and regulatory issues, will always be relevant and will always be an economically material part of the fact pattern. Then you come to the purple cluster, so aspects of the legal fact pattern affecting the borrower or relating to the borrower. So we have credit rating, the impact of implicit and explicit support, the borrower's actual income streams, its assets, and its ability to service the debt, prior and equal ranking debt, including security and legal constraints on the ability to borrow. So those factors, again, will always be relevant irrespective of the relationship between lender and borrower. So if you imagine a BlackRock situation, but where the borrowing entity and subgroup had granted security to third parties, or the subgroup was subject to prior ranking third-party creditors, which ranked ahead of the intergroup loans, clearly that element of the legal fact pattern is going to be relevant and is going to materially impact on the commercial rationality of the proposed new arrangements. Again, irrespective of the relationship between the related parties. Then we look at the orange factors, legal constraints on the lender in terms of the ability to lend or use cash. So that would cover situations, for example, where the lender has received third-party finance or government support or is subject to some other legal or contractual restrictions which affect its ability to utilize cash. So those hard legal restrictions will always be commercially relevant. And similarly, the reserves position, for example, whether the lender has negative net assets or negative P&L position, those solvency or reserves type issues will often impact the ability of the lender to lend and the terms of proposed lending, so whether it can be repayable on demand or not, and therefore clearly needs to be understood as part of the due diligence phase. And then we get to the final cluster of aspects of the legal fact pattern, so that in green, in other words, the circumstances of the proposed arrangement. So here we have purpose or commercial rationale of the arrangements. We have the proposed structure, repayment terms, currency, and so on of the loan. That will always be relevant. The terms of the loan in terms of the final three elements. So these are the ones that the BlackRock Court of Appeal decision are telling us are not relevant or potentially not relevant where it is a downstream loan from parent to subsidiary, but they will still be relevant in sideways or upstream loans where the lender does not control the borrower. In these circumstances, security and subordination, incurrence covenants, maintenance covenants will be arguably not relevant in downstream loans, but will still be relevant in sideways loans and upstream loans. And just to explain the last two items on this list, what do we mean by incurrence covenants and maintenance covenants? So this is the OECD terminology. So effectively, an incurrence covenant is a promise by the borrower not to do certain things, such as granting prior ranking security or making loans, for example. Whereas maintenance covenants relate to the maintenance of, for example, financial ratios on the part of the borrower, in other words, to maintain those ratios going forwards. That's an OECD distinction, and that's part of the considerations that, from an OECD transfer pricing perspective, are likely to be less economically relevant from a downstream loan perspective. So let's end and look at key takeaways from the BlackRock case. The first takeaway is about hygiene in communications, and that includes internal communications within the relevant group, but also communications between the group and its advisors. And as you can see from the BlackRock case and from similar cases like Singtel, the court did end up looking at specific emails between the client entity and their advisors, and those emails did color the interpretation of the facts. And therefore, it's impossible to establish that appropriate hygiene from the beginning and to assume, in effect, that such communications will be disclosable and will be part of the paper trail. Second key point is obviously to identify the legal and commercial fact pattern as an early part of the planning phase. And this includes legal constraints on the parties. It includes obligations to third parties, including third-party creditors, and also the ranking of third-party debts and obligations and security. Third key takeaway is to identify all the relevant stakeholders in terms of the design of intra-group financial transactions. And this point applies to all categories of related party transactions, not just financial ones. Stakeholders will include things like financial reporting, governance, duties of directors, withholding taxes, regulatory compliance, and so on. Point number 4 is to consider the proposed legal form and terms of financial transactions in the round, including covenants, security, related transactions, and terms, and so on. So especially where a proposed transaction is material, that probably means creating drafts of the legal documents or suite of documents at an early stage, because they provide a clear reference point for analyzing the transactions from an economic perspective. Point number 5 is the critical importance of documenting the commercial rationale of the arrangements properly. And that may be through board briefing notes or board minutes or both. In other words, not falling into the trap of Singtel, for example, where there was no documented commercial rationale at all, and therefore the court was forced to go through emails and try to reconstruct. So the client and the advisors were immediately on the back foot. And in fact, I would say that the commercial rationale should really be front and center and should be the prior thought before all other considerations. And then the final point, which I guess is the most obvious one, is that the pricing or benchmarking of the transaction can only happen after the form and the substance of the transaction has actually been designed. because skipping steps and going straight into pricing risks wasted costs, and it risks backtracking and delays to the project. So that's it on this case law briefing. Hope you find it helpful. Thank you very much.